case briefs, and so much more. LSData's got what you're looking for.
Imposing a penalty for a violation of federal banking laws set the stage for Hudson v. United States, a landmark 1997 case heard by the Supreme Court. The crux of the issue in this case lied within the Double Jeopardy Clause of the Constitution. If a penalty is civil, not criminal in nature, does the clause protect against further prosecution for the same offense? The leading figures in this case were John Hudson, chairman and controlling shareholder of the First National Bank of Tipton and the First National Bank of Hammond, Jack Rackley, president of Tipton and board member of Hammond, and Larry Bearsell, board member of both banks. An investigation by the Office of the Comptroller of the Currency, OCC, found that the men had exploited their positions within the banks. They arranged loans to third parties, which violated federal banking statutes and regulations. The OCC argued these loans were a cover for Hudson to regain bank stock he had used as collateral for defaulted loans. As a result of the breach of conduct, the government levied civil penalties against the trio. This they acknowledged and accepted. However, the storm clouds gathered when they were criminally charged over the same conduct. The case was appealed to the Supreme Court from the 10th Circuit Court of Appeals, which had ruled that the penalties levied by the OCC were civil and therefore did not infringe upon the Double Jeopardy Clause. The Supreme Court, echoing the lower court's decision, held that the OCC's punishments did not amount to criminal prosecution. Chief Justice Rehnquist, offering the majority opinion, stated unequivocally that the Double Jeopardy Clause was inapplicable as earlier proceedings were considered civil, not criminal. In conclusion, the Supreme Court's decision in Hudson v. United States set a defining precedence. The action of imposing civil penalties for misconduct doesn't protect the perpetrator from facing subsequent criminal prosecution for the same act. This was seen as a firm stance by the court in deterring similar future financial misconduct.
Case briefs, and so much more. LSData's got what you're looking for. Visit LSD.law, elevate your mind. Leave the stress of class.